All right, we'll now hear argument in 24-0567, Team International Services versus Berg. Counsel.
Good morning. May it please the court, my name is Todd Hepker. I represent the appellate Team International Services, Inc. in this appeal. Team seeks to reverse the trial court's February 2nd, 2024 order denying the defendant's amended motion to compel arbitration, and I request a reservation of 5 minutes for rebuttal after appellee's counsel has concluded her argument.
Very good.
Your Honors, the underlying facts in the record and the procedural background in the state court action are important to this appeal. This appeal does not involve a question of the abuse of the trial court's discretion. As we pointed out in our brief, it's beyond dispute that the court standard of review in this matter is de novo.
We're here today about appellant's amended renewed motion to compel arbitration.
That's correct.
And that was directed to the first amended complaint?
That is correct, Your Honor.
So the initial complaint, the first complaint, has been superseded?
Yes. I make a point in the...
And I read it. And I read it, but as I understand the law, but I want to hear you on that. That first amended complaint supersedes the initial complaint, and the initial complaint would no longer be in front of us.
Yes, and as you may have read, we simply filed our motion to compel arbitration when we responded initially to the initial complaint, which the brief contains all sorts of record cites to all the references to the employment agreement, the employment relationship, the for cause, without cause, termination. And then once I moved to compel arbitration on behalf of my client, they Mr. Berg and his counsel pivoted completely, removed all those references. And then the question became, and this was the argument that I made at the trial court level, is that we didn't consent to filing an amended complaint.
As I understand the rule, and I know you know this, once is a matter of course, and yes. Boca Berger, I think, makes that pretty clear.
Yes, the only thing I pointed out, I will concede that, except I could not find one case that said that a motion to compel is not a responsive pleading where then your one matter of course gets.
What do you do first with the rule? I've just pulled it up, 1100, where it defines pleadings, and as I know you know, a motion to compel arbitration is not captured there, and then the rule ends, no other pleadings will be allowed. So that would strongly indicate a motion to compel arbitration is not a pleading.
That's correct. And then my secondary argument to that was that you cannot rewrite history in that fashion, even if you take the position that the amended complaint supersedes the allegations in the original complaint. You cannot rewrite history and take a completely diametrically opposed approach to what you pled in the initial complaint to get around the arbitration. And there's a section in my motion and in the briefing, and I think in both briefs, the initial brief and the reply brief, where there's case after case, and they're federal cases, that cited for the proposition that the court could have struck that because the amendment would have been futile, because you cannot try to plead around.
But the problem, and perhaps you know this, there's no futility argument because they had every right to file an amended complaint.
Yes.
By operation of rule, and again, Boca Berger. So I understand futility, and I understand if it would be futile to file an amended pleading. That may be a good argument as to why pleading shouldn't be amended, but with a motion directed to the initial complaint, the rule would seem to this judge, I don't want to, again, speak for my colleagues, but to this judge that they had every right to file the amended complaint. And then you filed this amended, renewed motion to compel arbitration, correct?
Yes, and to strike the amended complaint on what I just, on the basis I outlined.
What I hear back from you on behalf of your client, and perhaps you as counsel, is that you're frustrated that they could say all those things in the initial complaint, and then the amended complaint is diametrically opposed to those things. But I just don't see that the rules allow you to be able to make that argument.
Yes.
But help me understand if there is something.
But my argument really is that the judge, that the trial judge should have considered those allegations anyway because they were part of the record. And when he didn't and completely ignored this diametrically opposed position, he erred.
But how could the court if it's a superseded pleading? And that, again, as I understand the law, you file an amended pleading, it supersedes the initial pleading.
There's a couple federal cases that I've cited in my briefing where the federal court has, the federal judges can go back and look at what was in the first initial complaint and then removed in the amended complaint. That is the site, Your Honors, Stokes versus Owens. It's a Northern District of Florida federal decision out of 2011 that a court can consider allegations from the initial complaint, even if they were removed in an amended complaint. And I just never, frankly, I've been practicing almost 40 years. I've never seen a situation like this where it's a complete change in theory, frankly, just to get around the question of arbitration. Just to get around the question. I don't think there's never been an allegation, and maybe there doesn't need to be one. There's never been an allegation that the allegations that were made in the initial complaint were incorrect or wrong, or somebody made a mistake when they put them in there. It's clear it was a tactical maneuver. And my argument to the trial court and to Your Honors is that it can't be that way. You can't rewrite history in that fashion to diametrically change your position just to get around the question of arbitrability of the claims or not. That's the argument, that you cannot do that. But even if, and the brief makes this, I think, extremely clear, even if you do not consider anything, any of those myriad of references to the employment relationship, the employment agreement that's in the initial complaint, and just forget about those, you still have the nexus that dictates that all three of these claims should be before the arbitration panel.
What is that
nexus? It's already been established.
What is the nexus?
The arbitration provision says that it's any and all disputes concerning the performance, breach, construction, or interpretation of this agreement, or in any manner arising out of this agreement shall be submitted to binding arbitration.
Does the Saunders case from our court say that such a provision isn't enough when you're, like in this case, you're making a religious discrimination claim?
The Saunders is distinguishable, as I pointed out in the brief, and the case that really controls this result is the subsequent decision by this court.
How is Sanders different? Because as I see the Sanders language, I've got it in front of me, Sanders, it looks like it's broader than the language we have here. I've got it, it says in Saunders, any claim or controversy that arises out of or relates to this agreement, something you don't see in the agreement here, or the breach of it, which sounds very similar, at least the breach part, to what the language was here. So how are we not bound by Saunders?
First, the language in the arbitration provision in this case concerns the performance, breach, construction, or interpretation. And the focus of my argument below, my argument here, is that these claims under the Florida Civil Rights Act certainly concern the performance of both parties that led to Mr. Berg's termination. And in fact, the agreement in retail detail is close to this provision and the holding in retail detail. I submit that the facts in retail detail, Merch LLC, are much more on point and analogous to this situation than the facts in Saunders. In retail detail.
What do you do with the Seifert language? And obviously that case matters for all the reasons you know, coming from the Florida Supreme Court. Let me just read to you, and this is actually from the answer brief, but it's a fair recitation of Seifert. If the duty alleged to be breached is one imposed by law that is generally owed to others, then the dispute alleging such a breach is not one arising from the contract. Isn't that precisely what we have here?
Yes, but there are all sorts of cases, Your Honor, where statutory claims are arbitrable, which is kind of the focus of that language. There's all sorts of cases where a fact pattern can lead to a cause of action that's statutory, or even a tort claim or a negligence claim that still fits within the language of the arbitration agreement and still has a nexus to the employment agreement.
In the First Amendment complaint here, is there any reference to the employment agreement?
Absolutely not.
Is there any reference in the First Amendment complaint to the initial complaint?
No, other than it's an amended complaint.
So, I mean, are we bound by the four corners of that document?
If you take that position and reject the argument that we just had 5-10 minutes ago, even if you're bound by what's in that amended complaint, I still submit to you that those claims.
How can we see the agreement then? That's the part. That's the disconnect I have. I mean, if we look at the four corners of a pleading that doesn't reference an employment contract, doesn't append the employment contract, doesn't talk about a breach of the employment contract, how can we see this nexus you're talking about?
Well,
performance nexus.
The amended complaint is replete with the interaction by Mr. Berg as CEO and other officers of the company, Mr. Moss, Mr. Shellhouse, and with the most focus between the interaction between Mr. Berg and between Matthew Moore, the head of the organization, head of team, and he characterizes his termination, Mr. Berg's termination, and there's a termination of some relationship. It has to be the employment relationship, and he's seeking damages as a result of that because of these statutory claims. And it's all about team's performance. Those statutory claims that are pled in there is all about team's performance of the employment agreement, because he claims that he could not do his job, that none of the things he wanted to do.
But isn't the duty that's alleged to be breached one that would apply to any team employee?
Yes.
That's what Seifert says. If that's all you have, that's not enough to get this nexus, connexity.
Well, because the nexus to the employment relationship in the employment agreement is Mr. Berg's performance of his duties under the employment agreement, and Mr. Moore on behalf of team, what he did. I mean, these same issues, as I point out repeatedly in my brief, these same issues are now being litigated in the pending existing arbitration that's being held in Orange County before three arbitrators, three lawyers. That's going to go to a final hearing in May, unless the schedule changes. These same exact issues that are going to be litigated in the state court action are being currently litigated in the arbitration, and that takes it out of Saunders. That takes away Saunders as well. Saunders does not involve an existing arbitration where the same claims, the same arguments, the same witnesses, the same evidence is going to be heard by that arbitration panel. I've suggested in our brief that this is an attempt to get a second bite at the apple by Mr. Berg. If for some reason he is unsuccessful in the arbitration, because it all depends, all of his damages in both forms, either form, depend on whether it was a for-cause termination or a without-cause termination. The damages flow from that determination that's going to be made by the arbitration panel at the final hearing. And that's the same thing that'll happen in the state court action. So you have a tremendous possibility, a risk of inconsistent results on the same issues, because that same thing is going to be argued in the state court action. And I think, I anticipate, I put this in my brief, I anticipate that Berg is going to argue, well, the damages aren't the same. Well, and maybe not. Maybe he's going to argue that he's restricted in the arbitration, in the state court action. But just think about what could happen. So we have an arbitration, we have a final hearing, he doesn't get what he wants in that arbitration proceeding, and then he turns around and tries to get the same damages that he couldn't get in the arbitration in the state court pleading. Now, there'll be questions of whether there's res judicata or collateral estoppel or issue preclusion in that. And I think that even militates toward compelling arbitration and moving these claims to arbitration, because you've got one forum, one fact finder, in this case, three arbitrators on an arbitration panel, experienced lawyers. They're going to be basically deciding the same issues, in my view, with the same evidence, the same witnesses, the same damages as a jury in the state court action if these three claims are not moved into arbitration. Do I have just 2 minutes left, or
Counselor,
I aided in my rebuttal?
You're down to almost 2 minutes remaining. You can burn it all now, or you can
I'll
save
wait
it
till
for
rebuttal.
Rebuttal, yeah.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Mary Walter, and I have the privilege of representing the appellee, Eric Berg. I want to start by thanking you for traveling to Daytona today so that we don't have to go to Jacksonville. We appreciate your time. As you have noted in the previous argument, this case is about a statutory dispute between two parties who happen to be involved in an employment contract. Now, the Florida Supreme Court has already held that the mere existence of a contract is not enough to compel arbitration. And in this case, the trial court correctly applied this court's binding precedent to find that the specific claims for employment discrimination under the FCRA are excluded from the provision between the parties. There are a few matters that I'd like to address in the statement of facts, but I think I can get to those as we go through the argument. I don't want to take too much of our time today because I know we're over for lunch. However, there are a couple of arguments that were made here, and I think I can clarify some points as we go along.
What about his last argument? I mean, we can read Saunders, and we can read the amended complaint, and we can read the motion directed to it. But what about his last argument that this case is currently in arbitration in front of three lawyers, and that could potentially create collateral estoppel, res judicata issues. Is that our concern today or no?
Your Honor, respectfully, it is not your concern. Now,
Why?
yes. So the rule here is that a party can contract to arbitrate claims. That's what we know. The rule that the Supreme Court has told us is that no party may be forced to arbitrate, but rather we can agree. That's why the courts require this nexus. Now, in this contract that was written after Saunders was decided, so the parties and the knew what the status of the law is, they used the specific language that you had cited earlier. And that,
I get all that.
Yeah.
In the cylinder of our case, if you're headed there, I understand.
Sure.
Not a problem. But apparently we have this parallel proceeding going on as we speak. Is that a feature of our analysis in this case? Yes or no?
no. Your Honor,
Why is that?
The rule is not that a party may not be compelled to arbitrate unless they agree, or perhaps there are issues that may or may not overlap. This isn't a race to the courthouse, or rather to the arbitration proceeding. It is a separate and distinct issue. As we have outlined in our brief, Mr. Berg has a constitutional right to litigate his statutory claims. Those claims have no nexus with his employment agreement. They were not contemplated.
Seaford
Yep.
and we
But
get
for that
Seaford and Jackson sailed.
Yes.
I fully appreciate, and Saunders.
Yes.
But so to say it in a sentence, if I can, this other proceeding is of no moment.
Exactly.
And so it's just because they got to the courthouse first doesn't preempt your client from being able to do what he's doing right now, advancing this Florida Civil Rights Act claim.
Correct. The rule is not that a party who gets to the courthouse first then can compel litigation of claims that are not related to an arbitration agreement. That's not what the Florida Supreme Court has said over and over again. The court has said, the Florida Supreme Court and this court in Saunders has said there must be that nexus. So again, we don't have an exception here for someone who races to the courthouse first and perhaps is able to file first.
And is that issue even in front of us?
I agree with that as well, Your Honor. To the extent that the...
Meaning it was not teed up below for us to even evaluate this ongoing proceeding in another forum.
Agreed. So we do have, during the hearing, that there was some discussion about Saunders between the two parties. That was not necessarily raised in the amended restated motion. There's a more brief discussion there, but it was part of the record in the trial court. However, that was not ruled upon necessarily. And while those issues were raised in the motion for reconsideration, that motion never got a decision from the trial court. So we don't have a decision.
It would be Mr. Berg's position that team should have sought out a ruling on that if they wanted us to address it, meaning on this ancillary issue dealing with the parallel proceeding.
Exactly. I think our preservation requirements are fairly consistent and well stated. Team did file a motion for reconsideration, which it was required to do if it wanted to challenge something new in that order. However, the correct procedure and the procedure that this court requires is that when the notice of appeal was filed, some mention was made to relinquish jurisdiction, get that decision, and then return, and that's routinely done here, and it just wasn't in this particular case. We also want to mention that there's a lot of discussion about these overlap and these arguments that are raised. However, it's not necessarily clear from our record that that's what's going to happen. We know from the arbitration demand that was attached to the amended motion to compel, that the claims that were raised by team when it makes this arbitration demand are that it has fired Mr. Berg for cause. And the cause is twofold. It's some text messages that were sent back and forth, and it's some financial issues. In the actual demand, there's a box that says, does this arbitration involve statutorily protected rights? And the box is checked no. This involves no non-statutorily protected rights. And then in the actual demand itself, there's a statement that team has received the EEOC demand that was filed earlier, within 100 days earlier. And it's willing to incorporate those within this arbitration. In the response that Mr. Berg files to that arbitration demand, he files an answer, counterclaim, and objection. The counterclaim raises concerns regarding his termination. He wasn't paid the severance benefits that he's entitled to. It raises no claims regarding the the discrimination at all. And in fact, it has an objection to the AAA's jurisdiction over EEOC claims because those are separate from the contract and they're distinguishable. Now, there's a lot of statements made about the transition between the original and the amended complaint. Now, we disagree that there are completely different claims raised at all. The initial complaint was filed on July 7th, 2024, and it asserts these very clear claims for employment discrimination based on religious discrimination, and then 2 counts of retaliation.
Do we even need to worry about the initial complaint? Or
No,
is
Your
it-
Honor.
I mean, it's over. It evaporated with the filing of the First Amendment complaint.
Absolutely. And the 2 federal decisions that were cited in the reply brief on that point are entirely distinguishable and not applicable. The first one is a footnote and in a complaint filed by a prison inmate. He files an amended complaint and he doesn't refer to some of the documents that were attached to the original complaint. There's a motion to dismiss hearing. The judge is talking about what can be considered, and they allow consideration of documents. But that was the Gross versus White case. And in that case, there's a specific mention that the amended complaint completely supersedes the original, so there are no more allegations. We then have a magistrate in Stokes versus Owens. He looks at an amended complaint again on a motion to dismiss, and he says, I think I can look at one allegation from the original complaint when I consider this amendment. But again, these are not motions to compel arbitration. These are specifically motions to dismiss, and that's not why we're here today. So our position is, as outlined in the brief, and as Your Honor has said, that there is just no reason to look at the original complaint. We're only here on the amendment. And the amendment makes no reference to the contract at all because it doesn't have to. We're talking about, as Your Honor stated, a cause of action that could have been raised by any employee, regardless of a contract. There's a prohibition about discriminating in the field of employment, and those are the claims that we've raised here. We're not seeking any contractual damages whatsoever. We're only seeking the personal injury damages, punitive damages, and then the attorney's fees that are permitted by that statute.
Would you characterize the arbitration agreement in this case as being less broad than Saunders, about the same, more
We believe
broad?
it's about the same. I think so, as you've noted in comparing the text, Saunders refers to any claim or controversy that arises out of or relates to the agreement. Breach of it shall be settled by arbitration. Ours says any dispute that concerns the performance, a breach of the agreement. I think they both would fall under the broad category as Seifert discusses, but we still need that nexus there, and there simply isn't one. But we do feel this is incredibly on point with Saunders, and Saunders does control, as the trial court had found. A few of the points that I think we do address in our brief that I'd just like to address quickly as to distinguishing Saunders. First, as Your Honor mentioned, that we have a preservation concern, but in terms of the substantive basis, we just talked about the breadth and the scope of the provision. We think that they're about the same. There's an argument about arguments that were raised and not rejected. We think that Saunders applies based on this court's holding, not necessarily on the arguments that were raised by the parties. The nexus we had addressed, while we do recognize that there is that Aztec medical case that talks about statutory claims being covered by an arbitration provision, that case is entirely distinguishable. It involves the FDUPTA, consumer protection claims, not civil rights claims. In fact, Aztec cites with favor the Edkins decision, which found an employment discrimination case was actually not part of the arbitration clause or covered by the contract. And then we've also kind of discussed the existing agreement. The appellant also brings up the Retail Detail versus Murphy case. That wasn't raised below. It was decided shortly before the hearing in December of 2023, but it was definitely on the books before the motion for reconsideration was filed and certainly before this appeal was initiated.
And there was a failure in Murphy to respond to the motion
Yes.
to compel arbitration. I mean, that's a categorical difference, isn't it?
Exactly. So I think the procedural aspects of it, but the failure to respond, but also the court notes, Judge Edwards notes in that case that the complaint itself talks about performance. This is a request for an accommodation. There's a performance allegation. Nowhere in our amended complaint do we talk about Mr. Berg's performance of the contract. It's really just his, the conduct that he feels he is subjected to. Whether or not that qualifies as discrimination is another day, but the allegations in both of those cases are entirely separate, and it brings this more in line with Saunders and other cases. We also thought it was interesting in the Navarro case, which is a third DCA case. This is a case by an attorney who's terminated for, she alleges, for pregnancy discrimination. She raises multiple claims. Some of them are compelled to arbitration, some of them are not. When the third DCA affirmed that case, it doesn't talk about parallel proceedings and any concerns in that regard. It just notes that applying the contract to the law, the breach of contract claims would be arbitrated under her employment agreement with her employer, and the claims for intentional infliction of emotional distress and discrimination would be subject to a court's consideration. So there, in the third DCA, they didn't find that to be a concern, and we don't believe that either. We also think that the Saunders decision, as well as Navarro and Bateman, involve broad arbitration provisions that talk about any matter, any dispute. Still, no nexus found with the claims that that don't reference the contract. So we feel that is relevant to the trial court's consideration and binding there. I think the only other, we did want to note that our the claims in I think I mentioned that the amended complaint, the motive, I think it was pretty clear during the hearing that the motive on this amendment was not to thwart an arbitration, and I think it's important that the federal cases upon which the appellant relies were claims that were covered by arbitration and then changes to those. So all of those cases are entirely distinguishable based on their facts. None of them involve discrimination or anything similar to this scenario. So, Your Honors, unless there is any additional questions, I believe that our answer brief adequately states that our basis for affirmance, and we believe the trial court followed Saunders as it was required to do, and we ask this court to affirm both procedurally and on substance.
Thank you, counsel.
Thank you so much.
I just wanted to, and I understand Your Honor's comment about what happened in retail detail, where the plaintiff didn't respond to the motion to compel. But if
That's a big deal.
but the court did
Wouldn't
not.
the court force to compel arbitration?
Yeah, I would submit, though, that the court wrote an opinion on it, and the analysis, although it notes that a response wasn't filed, it doesn't base its ruling on that. This
So
court,
it would be dicta,
well,
would it not?
that the holding would be dicta?
Well, I mean, if
I-
the statute says if you don't respond, the court shall, I think it shall, compel arbitration, right?
Yes, but I don't know why this court would have gone and did at least
I can't speak to another panel, but.
3 pages of analysis about it. I mean, it's a discrimination case where the lady all came down to her performance, whether she could perform or not. She had gotten injured at work. She got transferred to light duty. I think she requested and then got transferred to light duty. And then she was terminated after she filed a workers' compensation claim, claiming that she was discriminated against. And the arbitration provision in that case is very similar to the arbitration provision in this case. And this court in retail detail said because her claims required a reference, a reading of the provisions of the employment agreement, it ruled there was a sufficient nexus. And I submit that that is on all fours with our case. They can say whatever they want to say about that there's no reference in the amended complaint to the employment agreement. I'll give them that, but it clearly is about Mr. Berg's performance and about team's performance. And the arbitration agreement in this case, the provision, says that any dispute concerning the performance or the breach is arbitrable, or the construction or the interpretation. And there will be all sorts of arguments as to whether Mr. Berg was terminated for cause or was he terminated without cause. And their damages depend on that. I'll mention one more thing. There is a case, it's not cited in the brief, it's the Brasington versus EMC Corp. Out of the first DCA, 855 Southern 2nd, 1212. That is a civil rights claim that was held to be compelled to arbitration with a similar agreement. So there is a civil rights case where that has been arbitrated.
Hey, counsel, thank you.
Thank you.
Thank you.
Well, thank you both for your arguments today, and
Thank you.
please have safe travels. While we appreciate coming from Jacksonville, I know you all have to go back to your communities, so have a great election day. We will be in recess.